Federal Circuit issues mixed ruling on blood analyzer trade secrets. The Federal Circuit has affirmed in part, and reversed in part, a district court ruling on an alleged misappropriation of trade secrets for blood analysis technology. In October 2014, Halifax sued Alcor and Frappa for trade secret misappropriation under the Rhode Island Uniform Trade Secrets Act, RIUTSA. Halifax also sued only Alcor for infringement of 2 of its U.S. patents and for copyright infringement. Alcor counterclaimed, seeking, among other things, declaratory judgment of patent invalidity. However, by the time of the jury deliberations, the only issues remaining related to trade secret misappropriation. There are 2 trade secrets relevant to this appeal. The conversion algorithm trade secret, which comprises portions of computer program source code concerning the conversion of photometric measurements, including source code containing 4 specific conversion constants. And the alleged signal acquisition trade secret, which involves the process by which Halifax's devices gathered SR-related raw data through signal acquisition. But the court struck the alleged signal acquisition trade secret from the jury verdict form, finding there to be no record evidence of trade secrets involved in any of the steps that are discussed regarding how the apparatus would be programmed to operate, other than with respect to the conversion algorithm. The jury returned a verdict finding Halifax had proved that the conversion algorithm was a trade secret, and that defendants had misappropriated that trade secret. After the trial, the district court granted defendants a new trial on both liability and damages for the conversion algorithm trade secret. Regarding liability, the court found that the verdict was against the clear weight of the evidence, reasoning that because there was little evidence that Halifax's algorithm could produce highly accurate results in a non-Halifax device, defendants could not have used Halifax's algorithm for any purpose. On appeal, the Federal Circuit held that the district court didn't err by preventing the jury from considering the alleged signal acquisition trade secret, finding that Halifax had failed to show the existence and scope of the alleged trade secret under RIUTSA. A plaintiff must do more than just identify a kind of technology, and then invite the court to hunt through the details in search of items meeting the statutory definition. To meet its burden, said the court, the trade secret owner must describe the subject matter of its alleged trade secrets in sufficient detail to establish each element of a trade secret. Here, said the court, Halifax not only failed to describe the alleged signal acquisition trade secret with sufficient detail, but also failed to identify its proper scope. Because Halifax failed to identify the scope of the alleged trade secret, a jury would not be able to distinguish which aspects are known to the trade from those which are not. The lesson for plaintiffs is that you can't be conclusory in making a trade secret infringement claim. You need to get into the details of what exactly was allegedly stolen and why it was secret, not just state what the technology was used for. Learn more about protecting your trade secrets. Book an appointment with us at www.eonlaw.com. Eon Law. Unleashing Genius.